The last panel of the day. Thank you, everybody who stayed. My name is Lori Sands. I am an environmental attorney at Riker Danzig in Morristown, New Jersey. I am also part of the sponsorship of this conference as the chair of the environmental section of the New Jersey State Bar Association. And I just want to thank Michael because I think he did an excellent job with the conference. The last panel of the day is on water issues. We have two panelists, Phyllis Feinmark, who is the Chief Water and General Law, who is the Chief of the Water and General Law Branch of the U.S. EPA. She concentrates on wetlands, field material disposal, and NIPD's compliance and counseling. She is going to talk to us today. I just want to say, too, before she worked at the EPA, she did work at the Army Corps of Engineers. She's going to talk to us today about two topics. Phyllis is going to go, and then we're going to have Michelle, and then Phyllis is going to go again. But her first topic is going to be wetlands jurisdiction.
Thank you, Lori. I don't want to make any mistakes with this. The first time I ever gave a talk, it was when we still used the slide projectors, and I gave half my talk going backwards, and no one ever told me. So this makes it go. Thank you, Michelle. Okay. I would also like to thank Mike. This has been a terrific conference, and I have a lot to cover in a little time. Luckily, the third person didn't show up, so I have a little more time. But also, I am perhaps the only person in Region 2 who can talk faster than Walter Mugden, so I'll give it a try. Also, I'd like to get one other thing out of the way first, a shout-out to Rob Yalen, because everyone else is doing it. Hey, Rob. He's our litigator extraordinaire in the Southern District. Welcome to what must be the fifth or sixth time I've discussed wetlands jurisdiction in this forum. Here's my disclaimer. And, okay. I want to tell you about some very exciting, yeah, that's the right one, recent developments regarding the Clean Water Act definition of waters of the U.S. But in order to do that, I ask that you indulge my need to lay groundwork and place actions into context. So let's start with the current regulatory definition of waters of the U.S. It's been in place since 1993, and it describes, we're going to call them WOTUS, just like POTUS, but with a W, and we're very cool in wetlands work. And as waters used in commerce or navigation, tidal waters, interstate waters, tributaries to those waters, and wetlands adjacent to those waters. Although you would think that's relatively straightforward, you would be wrong. The reason is two Supreme Court decisions that altered our understanding of Clean Water Act jurisdiction. Swank was decided in 2000, and its main impact was to eliminate federal jurisdiction over most isolated waters, which are waters that do not have any surface connections to them. Think Great Salt Lake. The matter before the court at the time was the validity of an Army Corps of Engineers regulatory guidance letter, which stated that if migratory birds used a body of water, that was adequate to establish an interstate commerce connection and make an otherwise isolated water body susceptible to federal jurisdiction. By finding that the use of the migratory birds standard does not result in jurisdiction, we feel the court overlooked the benefits that these waters have on watersheds and the value of isolated waters as habitat. The next decision was Rapanos in 2006, where the court addressed EPA and Corps of Engineers Clean Water Act jurisdiction by evaluating when a tributary or wetland qualifies as a WOTUS. It was a mess. 5-4 decision, 5 opinions, plurality of 4 justices agreeing that jurisdiction is limited to relatively permanent, standing, or continuously flowing bodies of water and wetlands with a continuous surface connection to relatively permanent water bodies. Got it? Justice Kennedy concurred in that judgment, but with his own reasoning that any type of water can be jurisdictional if it meets certain functional requirements that he termed a significant nexus. These two decisions together created much uncertainty over the exact reach of WOTUS and greatly complicated the process for jurisdictional determinations. The guidance issued by EPA and the Corps after Rapanos in 2007 requires the Corps to determine on a case-by-case basis whether a water has a significant nexus. The result is that so-called routine jurisdiction determinations are anything but, with a determination taking months and requiring massive amounts of paperwork. Clarity went out the window. Are these waters of the United States? It's a quiz. New York Harbor, Always, yes, that's easy. Woodland stream, it depends. And vernal pool, gosh, that one's complicated. But it's probably isolated with no surface connection, back to the Swank decision. So your best bet is no, not a WOTUS. Even with the guidance, the field remained confusing and complex. The regulatory agencies were confronting substantial costs, not coats, I made a typo there, and inefficiencies in determining jurisdiction. The Supreme Court, Congress, state and local officials, industry, agriculture, and others asked for clarity. And most important, streams and wetlands, which are the foundation of our water resources and are now more than ever vital to public health, the environment, and economy, are inadequately protected. Streams that might now be considered outside of core jurisdiction because they flow for only part of the year are 59% of the country's stream miles. There's also a need to protect some geographically isolated wetlands and waters, which may constitute as much as 20% of the remaining wetlands acreage in the U.S. And it's of paramount importance to protect drinking water sources, since over 117 million Americans are dependent on waters that may not currently be within federal jurisdiction. So a decision was made by the federal partners to propose a joint rule that clarifies protection for upstream waters that are vital to the health of downstream waterways and communities. Oh, I'm just going to say this snuck in. You can read it, I won't say it. In furtherance of that goal, the EPA Office of Research and Development has prepared a peer-reviewed draft report entitled Connectivity of Streams and Wetlands to Downstream Waters, which provides a scientific framework for clarifying Clean Water Act jurisdiction, including a description of the factors that influence connectivity and the mechanisms by which connected waters affect downstream waters. It summarizes over 1,000 pieces of scientific literature and will help to inform the agency's work. Some of the draft conclusions include the finding that all streams are connected to and have important effects on downstream waters, wetlands and open waters and floodplains of streams and rivers and in riparian areas are integrated with streams and rivers, and there is not enough information to generalize about wetlands and open waters located outside of floodplains and riparian areas and their connection to downstream waters. The draft rule itself, and we're finally there, yes, is intended to be consistent with Supreme Court decisions and is based on best available science as set forth in the Connectivity Report. It creates 3 categories of waters of the U.S. The first is waters that are unquestionably jurisdictional. This would include waters that are jurisdictional based on a plain reading of the Clean Water Act, unchallenged regulations and case laws such as traditional navigable waters, interstate waters, territorial seas, and impoundments. This category also includes those waters that are unquestionably jurisdictional based on a scientific finding of a significant nexus to traditional navigable waters. So consistent with the Connectivity Report, that means tributaries of TNWs, interstate waters, and such are now automatically jurisdictional, whether or not they're permanent and free-flowing, because by definition, they have important effects on downstream waters. For the same reason, wetlands adjacent to tributaries are also categorically included as waters of the U.S. The second category is other waters, including wetlands, that must be reviewed on a case-by-case basis. If the Corps determines that they have a significant nexus to TNWs, interstate waters, or territorial seas, either alone or in combination with other similarly situated waters, including wetlands, located in the same region, they are jurisdictional. Some of that phraseology comes from Kennedy's decision still in Rapanos. They're like magical words. The final category is those waters that are never WOTUS. For instance, some ditches, artificial lakes and ponds, upland construction depressions, prior converted croplands, waste treatment systems, and groundwater. This new definition of waters of the U.S. will apply across the board to all Clean Water Act programs. Finally, although there's been much outcry and much press, it does not expand federal jurisdiction. Instead, it provides new clarity and predictability. When finalized, the rule will eliminate confusion and restore protection to 20 million acres of wetlands and over half of the nation's streams. Most seasonal and rain-dependent streams are clearly protected, as are the wetlands near them. Protection of waters that have uncertain connections with downstream waters will be determined through a case-specific analysis of its connection to determine if it is significant. No new waters have been subjected to jurisdiction, and no exemptions have been removed. Groundwater is still not jurisdictional, and there's been no expansion of jurisdiction over ditches. The draft rule was published in the Federal Register on April 21st, 2014. It takes into account over 4 years of dialogue and over 415,000 comments. Nothing like the 2 million from this morning, but still a hefty amount. The preamble and appendices total 324 pages, and the rule itself is 45 pages because it changes every definition of waters of the U.S. in the regulations that have been promulgated pursuant to the Clean Water Act. That would include definition of waters of the U.S., discharge of oil, designation of hazardous substances, EPA-administered permit programs, and the regulations relating to 404, the Wetlands Program. Finally, the relationship between agriculture and waters of the U.S. determinations is frequently contentious. Current regulations provide that discharges of dredged or fill material from normal farming, silviculture, and ranching activities do not need permits. The draft regulation specifically preserves those agricultural exceptions and exclusions and goes beyond that to state that certain practices are normal and thus do not need a permit. In order to further clarify jurisdiction in these cases, EPA and the Corps coordinated with USDA to develop an interpretive rule for agricultural activities. It was issued on March 25th. It's effective immediately, and it lists 56 specific conservation practices that protect water quality and thus will not be subject to Clean Water Act Section 404 permitting. There's also a March 25th MOU between the agencies where they agreed to work together to implement the exemptions, as well as periodically review and update activities that would qualify for exemption. You know, I should give a shout out right now, Michelle, to the state of New Jersey, which is one of the only 2 states that has assumed the wetlands program pursuant to a provision of the Clean Water Act. New Jersey does a wonderful job, and we're just trying to, no, we really do. It's much, much more restrictive than the federal program, and we really appreciate it. The other state is Michigan, and we're trying to figure out if this has any impact on what you guys are doing.
So
We've got fingers crossed on that. Finally, this is to wrap it up. This is a photo of a treatment wetland next to a tidal wetland under the Brooklyn side of the Brooklyn Bridge. And no, I do not know if it's jurisdictional. Thank you.
Thank you, Phyllis. Michelle is going to talk to us. She's already been introduced. She is the Deputy Commissioner, but prior to that time, she was the Assistant Commissioner of Water Resources Management, and so she has a lot of knowledge about water issues in New Jersey. She's going to do an overview for us on that issue.
So this is that deeper dive I promised you a little earlier. And one thing I learned when I came to the water program at DEP from my energy spot at DEP is every time you talk, there is some water pun intended. So it is amazing. No matter what you say, you know, deeper dive or, you know, let's float that idea. It amazed me. The first month I said, oh my God, I have to stop because everything has a water pun. I can tell you that I came to the water program at an extremely exciting time at DEP. It was about 4 months before Sandy, so imagine being New Jersey's water girl in a post-Sandy world. And you heard me talk earlier about the devastation to our infrastructure in the state of New Jersey, and I will tell you that the personal backdrop to that was 3 weeks of about 18 to 20-hour days at our State Emergency Response Center, making sure that we were getting fuel and generators to all of these wastewater treatment facilities that unfortunately were dumping sewage because they just didn't have energy. We just couldn't get them diesel fuel. Their generators were burning out, and it was quite the situation. So Sandy gave us $2.6 billion estimated. I said earlier a lot of that is FEMA project worksheets, meaning that it will be reimbursed through FEMA, about $161 million. And then above and beyond that, we have improvements that range about $1.6 billion on resiliency that we're working on. The single most largest devastation we had in this picture tells a bit of a story is Passaic Valley Sewage Commission. This is the 3rd largest wastewater treatment facility plant in the country, not just on the East Coast or in New Jersey, but in the country. It serves 500 million customers, and it was totally inundated. You can see here where it is just filled to the rims with water. And PVSC's operation basically is a very large cavernous facility underground that takes acres and acres of land and moves energy through this process in order for them to take care of the treatment of the water that comes in. The entire bottom level of the facility was flooded. And when we took a tour, we brought FEMA leadership to the plant, and we walked them through the cavernous area that is PVSC, and you could still see weeks after, months after, wires that were hanging that were still dripping salt water. Salt water still coming out of these electrical wires months after Sandy. So we've been the subject of some really unique situations of what happens when salt water inundates these types of facilities and what is the long-lasting impact. And we have, let me say that we have a great partnership working with our federal agencies on our recovery, but let me also say that we've gotten into a lot of uncharted territory where we are really pushing the limit on hazard mitigation funding through FEMA. It's called 406 hazard mitigation money. That is the unlimited pool of money if you can prove need. And the hazard mitigation money is for the purpose of building resiliency and trying to show that these types of electrical systems are vulnerable for the years to come, not just in the immediacy after the storm, is quite a challenge. But we're up to the task, and we were very successful in proving to FEMA that this PVSC system, which is a series of about 25 different buildings above ground but all connected underground, is one system that needs to be considered comprehensively for funding for hazard mitigation. And as a result of it, I think they called it that it was a skyscraper laying on its side underground. So, they came along with us, and as a result of that, we'll probably have the largest resiliency project under 406 hazard mitigation at this particular power plant. But the other part of this is, let me still say that a lot of these power plants are still in a recovery mode. They are still operating on, as we say, Band-Aids and bubble gum, and their ability to rebuild will be years and years into the future. And the good news, and thank you to our EPA partners and the federal government, in that all the Sandy money had a 2-year spend on it. So from the date that the federal government obligates your Sandy money, you have to spend it in 2 years. Well, there's no way you rebuild water infrastructure in 2 years. And our federal partners acknowledge that, and so we've been able to get a waiver of that. But that just gives you an example. So how do we make ourselves more resilient in our water world going forward? We've established different guidance for resilience in the state around the areas of auxiliary power. You heard me talk about, all the grid issues that we had. Emergency preparedness and response. Critically important that we spend time with our facilities on how they and we collectively respond in the future. We had a lot of communications challenges. They had a lot of communication challenges. In terms of moving assets, we've identified ways to work within regions for emergency response so that our critical facilities can share assets at a local level and move them more quickly, and we can stage them in advance. Flood protection. How will we rebuild to provide proper flood protection, whether it means elevating those motor control boxes and that equipment out of harm's way, because you can't elevate a wastewater treatment facility, right? But you can elevate the critical parts of it. Or how do we dry flood proof and build flood walls so that we can protect these facilities? And last and the most important, in my opinion, is asset management. Something we, not just in the state of New Jersey, but nationally, we have ignored for just way too long. We need to get our arms around, responsible asset management, and I'll talk a little bit more in depth about that. So, I talked earlier in general about how we take a comprehensive approach across all of our media at DEP, air, land, water, natural resources. But in the water program specifically, we've taken an approach of mapping our critical infrastructure, looking regionally at permit priorities in those areas, and then again, what are the stressors? So the great example I like to give, if you're familiar with the state of New Jersey, we have the Barnegat Bay. In fact, Governor Christie has a 10-point plan for Barnegat Bay. It is one of his legacy items as a governor, and we've been successfully implementing his 10-point plan for Barnegat Bay over the last 4 years. Barnegat Bay is a watershed that is all about non-point source pollution. Okay? We found things like the fertilizer law, which even though it was a statewide law to have some controls on the type of fertilizer so that when stormwater hits it and it goes in our water, we have better protection. But it's things like that. It's things like the recreational activity on the bay. It's the development around the bay. But it's all non-point solution. We do not have any large dischargers discharging into Barnegat Bay. So that's one watershed, and that's the type of comprehensive plan that has to deal directly with non-point source pollution. Now we compare that with the Raritan up north. The Raritan is all about point source pollution. We have large dischargers into that body of water, therefore different stressors on the water body. There is no way we can take one approach to deal with these two water bodies. So we have to look comprehensively at what the stressors on each of those are and bring those unique solutions on how to do that. In the Raritan, a TMDL probably makes sense because we have all these dischargers that we can directly regulate. Barnegat Bay, probably not so much. Think we need some other types of innovative solutions, which is part of the governor's 10-point plan. So that's an example of how you compare watersheds and how a one-size-fits-all doesn't work in the great diverse state of New Jersey. We also try to learn from our neighbors. We've spent a lot of time in Pennsylvania and New York City looking at their green infrastructure programs. So the beauty of, when I hear Emily talk this morning, the beauty of their program is they are one regulator. They are one entity, so they can control what they do. Now, albeit it is massive, and she's got an amazing job to do, but she can do it. It's one entity that they control. In New Jersey, as I said earlier, we have these 526 municipalities. When we regulate CSOs, one CSO impacts 5 or 6 municipalities. Just imagine sitting 5 or 6 mayors down and a wastewater treatment plant that's in a 6th community to come together on a comprehensive solution. Not an easy thing. We are finding our way around it, and we can do it, and we are doing it. But we've learned a lot from our neighbors in Pennsylvania, as well as EPA, as well as New York City on green infrastructure. They have some great, Philadelphia has an awesome green infrastructure plan. We sent a team there and we did some information exchange, and the same, we came up to New York City and talked around their Plan NYC and all the green infrastructure embedded in that. And so green infrastructure is a very big part of what we do. You've heard me talk about combined sewer overflow. In our permits right now, we do have long-term control plans. That's a big part of these. Green infrastructure is required in the first 5 years of the permit. This is a less expensive way to get the ball rolling, but it does have impact. I wanted to stand up and cheer when Emily said this morning, people think you're kind of copping out on green infrastructure. Absolutely not. It has a tremendous impact, and we want to make it a part of our permit up front. We realize that in order to be successful on our combined sewer overflow, that this is going to take 20 to 30 years. This doesn't happen tomorrow. It is impossible to believe it happens tomorrow. And I think this is why administrations have stepped back so many times, because it's that fear of stepping into the pool and saying we're going to leap forward. What we're working with our communities on is saying this is a 20 to 30 year process. Let's start today. Let's have iterative improvement along the way. Let's find you the funding so that you can do the pieces along the way, and we can celebrate those milestones as we hit them. And 30 years from now, we'll have solved our concerns. Can't do CSOs, in a bubble. We have to look around stormwater management more comprehensively. We are doing a complete overhaul of our municipal stormwater permitting program, our MS4s. Again, green infrastructure is a big part of this, and a lot is geared toward best management practices. We're doing an audit program in this area where we're sending teams out to audit different permits to see what we learn from that and then get everybody on board in some type of a hopefully compliance assistance way. The last thing we want to do is go out and ding our municipalities. They're greatly challenged, so we need to work alongside of them to bring them along on things that work. So asset management. My biggest concern post-Sandy is it's just like everything else. When you're in the immediacy of an event and you feel that urgency, right? You don't have that business as usual mentality. Everybody thinks, oh, this is a paradigm shift. And then as you wane from it, people forget. People forget. And my biggest concern is that we're going to fall back into a business as usual mentality when it comes to the devastation that we had from our infrastructure. So keeping that sense of urgency is extremely important when we talk about asset management. We have to continually remind folks of the challenges we have in this area, and we have to be a cheerleader for change on this. We have to find ways to fund it. And again, we're talking about taking steps now that will take us 30 years to accomplish. So what we're trying to do with our facilities now is do some ROI, some return on investment. We had a very big water main break last year in Swimming River in Monmouth County, right at the height of the summer season. We were pretty concerned. Now, thank God, New Jersey American Water was able to get that pipe back up very quickly. We could have had a really bad situation on our hand. How much money does it take to address an emergency in the moment? A heck of a lot of money, right? If we can plan over time responsible asset management plans for 20 to 30 years and make small investments along the way, the ROI will prove that that is less expensive at the end than dealing with these emergencies up front. So we're doing some modeling around that. We have some great cheerleaders within our industry who are helping us along because they do it and they're really good role models for how to get it done. So I just want to overemphasize the importance of iterative improvement over a long period of time. Celebrate the milestones along the way, keep the momentum, and I think we have a lot then to cheer about many years from now. Can't do any of this without money. I talked about our EIT earlier today. The beauty of our EIT, our Environmental Infrastructure Trust in New Jersey, is when we get our annual state revolving fund money from EPA, our annual allocation, we are able to leverage that 2 or 3 times through the EIT when we take that out to the bond market. So the ability to enhance that money and bring back 2 or 3 times the federal dollars is a tremendous opportunity for us. What we do in this program is we create priorities so that we can get funding in the right places at the right time to support the priorities that the state thinks is important. A great example of this is in our last round of funding for EIT. In addition to Sandy, we put an emphasis on green infrastructure, we put an emphasis on projects in Barnegat Bay, and we put an emphasis on asset management. So if you were bringing in a project for one of those items, you're going to get a higher ranking, which means that your loan amount, you're going to get more principal forgiveness. That's free money, grant. For municipality, you have to call it loan forgiveness. But you get a higher rate of loan forgiveness in those select categories, which means then also that your loan is at an extremely low rate. And we're able to do loans for, 0.25 basis points. You can't get that on the market. So this is a really great program, and we're proud that we have it in New Jersey. On the energy side, you heard me talk earlier about the Energy Resiliency Bank. Also what we're doing is we have a $25 million hazard mitigation grant program that we are doing at the local level for energy projects. 80% of these that came in are generators. We're not really excited about having new megawatts of generators in the state, but we realize in an emergency situation, for many facilities, that's what we need. I see Jean Fox nodding her head on that, exactly. On the drinking water side, we've transformed the program that we have around how we keep our well records. We have over 500,000 well records, and we have a lot of issues around our private wells in the state of New Jersey that we just can never get our arms around. The process that we went through allows for better emergency response. It allows us to better understand what's going on with our private wells in the state of New Jersey, better access to information. And that GIS that I talked about before, we have all of our private wells GISed on data layers so that folks can understand what types of groundwater issues might be impacting their private wells, and as a result of that, what type of affirmative testing they should be doing. We can't require testing of the wells until they sell the house. But we can certainly educate them what people should be looking for. And we have, many naturally occurring situations in New Jersey in our environmental conditions and groundwater that we would like people to be voluntarily testing their wells and see what's going on. We have an outstanding water monitoring program in the state of New Jersey. So I talked about that 127 miles of coastal shoreline. We maintain throughout the summer season from pre-Memorial Day to post-Labor Day a very comprehensive monitoring of our marine water. We take hundreds of thousands of samples over the course of the summer. We do daily flyovers. We test for chlorophyll, which gives us examples of where algae may be blooming out in our waters. As a result of that, New Jersey beaches are open 99.9% of the time each year. We get great ratings in the NRDC annual beach report. We're usually up amongst numbers 1 and 2. In addition to that, we do ambient lake monitoring, again, hundreds of thousands of samples that we do on a regular basis. We monitor and we test over 900 individual stream segments over 3-year periods. And all this information is available on our website so that folks can see the quality of our water at any given point in time. Moving forward, very important that we continue. I talk again about breaking that business as usual attitude. How do we keep our good transformation, our positive regulatory reform moving forward, and keeping the issue of the importance of infrastructure at the top of everyone's mind? And why do we do that? So this is a picture of mantle oaking post Sandy. You can see this is where the Barnegat Bay and the ocean met in the middle of a community. And there's still an awful lot to do. So thank you again, and that was your deep dive on water from New Jersey.
Thank you, Michelle. Now we're going to have Phyllis again, and she's going to be talking about hydraulic fracking.
You probably would have noticed. I grabbed the wrong notes. I was going to give the same talk over again, but with a different set of slides. I thought I'd mix things up. Anyway, so now we're going to talk briefly about hydraulic fracturing in the context of shale gas production. I'm going to skip some slides, but the PowerPoint and ancillary materials I've provided are very self-explanatory. So here's my disclaimer again. I'm never exactly sure the level of knowledge that anyone has regarding hydraulic fracturing. I know everyone hears about it, but I'm going to tell you a little bit about it so we can pinpoint the environmental impacts. Shale gas is a natural gas produced from shale formations, which are dense rocks, rather than the porous rocks that allow underground reservoirs of gas to form. To reach the shale gas, energy companies must crack the rocks open by injecting them with high-pressure liquids. Little known fact, the first commercial gas well drilled in the U.S. in Fredonia, New York in 1821 was a shale gas well. But subsequent conventional wells produced much larger volumes, and shale gas production was quickly overshadowed. The lower 48 states have a wide distribution of highly organic shales containing vast resources of natural gas. You've most likely heard of some of these shales by now. We were talking about some of them earlier with regard to the rail transportation of crude oil. The one that impacts our region here is the Marcellus Shale. As you can see, it reaches up into the Delaware River Basin and western New York. It extends into the Catskills and the New York City watershed. These unconventional natural gas deposits are often lower in resource concentration, more dispersed over large areas, and require well stimulation or some other extraction or conversion technology. So historically, these wells have been thought to be too expensive and limited to be economically viable over a long period of time. But here are the numbers on conventional gas versus technically recoverable shale. And as you can see, there's a huge incentive to make that gas available. Three factors have made shale gas production economically viable: advances in horizontal drilling, advances in hydraulic fracturing, and rapid increases in natural gas prices as a result of significant supply and demand pressures. Natural gas burns cleaner than coal and fuel oil, but methane, the principal component of natural gas, is a very potent greenhouse gas, and it is directly released to the atmosphere in the course of drilling. We're going to talk a little bit about the actual hydrofracking process so that you're better able to recognize the environmental impacts. The use of horizontal drilling is quickly becoming the preferred method for most productive shale gas wells. Horizontal wells are constructed in the same manner as vertical wells until the well bore reaches about 500 feet from the expected production zone. That's called the kickoff point, and that's where the well bore begins to turn slowly to become a horizontal well. The drill bit moves into the shale formation at an angle until it reaches what's known as the production zone. That portion extends up to 10,000 feet horizontally into the shale formation, creating a major increase in accessing the production zone as compared to that which would be reached by a vertical well. Once the well casing is in place, the outer casing, the drilling rig is removed and they bring in the well completion facilities. Water tanks containing fracturing fluid, pumper trucks, and a work rig are brought onto the site. The completion company lowers a special perforating tool into the case to the farthest point of the well. They attach an explosive charge to the end of it, and it's ignited. The blast breaks through the production casing and into the shale formation, creating microfractures and connecting natural microfractures in the shale. At this point, the shale is still very tight, and only minimal gas is produced, so hydrofracking is performed. So first we had the horizontal drilling, and now we're going to do the hydrofracking part. They're two distinct processes in order to stimulate well production. The company injects large volumes of water, a variety of chemicals, and thousands of pounds of sand under extreme pressure through the well boring casing and out into the formation. The fracture fluids are primarily water-based fluids mixed with compounds that carry sand into the fractures. The fluid under pressure causes microfractures in the formation to open, releasing trapped natural gas into the well in economic quantities. The sand lodges in the fractures and allows them to remain open as the water and chemicals are forced back up the borehole with the natural gas. For a horizontal well, anywhere from 3 to 7 million gallons of fluid may be necessary to make the fracking fluid for a single well, and between 20 to 50% of that fluid is expected to flow back up to the surface. Here's a summary, and I'd like you to note that shale gas is expected to make up an increasing share of total domestic gas production in the next 10 years. And here are some photos of various aspects of the hydrofracking process. Now we can move on to discussing EPA's regulatory framework for these activities. Clearly, natural gas exploration, drilling, and production all have potential for environmental impacts. If we were to break these potential impacts down by statute, these might include discharges of pollutants from a point source to waters of the U.S. pursuant to the Clean Water Act, public water system contamination and contamination of underground sources of drinking water covered by the Safe Drinking Water Act, Clean Air Act emissions from stationary sources, information regarding chemicals used that should be reported pursuant to TSCA, RCRA non-exploration and production waste, and waste that may present an imminent and substantial endangerment to health or the environment, and CERCLA 104 Response Authority and CERCLA 106 Abatement Authority to address releases that may present imminent and substantial endangerment. Due to time constraints, I'm going to cover just the Clean Water Act and Safe Drinking Water Act, although, as I said before, I've included PowerPoint slides and materials on the other aspects. Hydraulic fracturing activities may result in discharges to surface water, which are subject to requirements under the Clean Water Act. EPA, or an authorized state agency, issues permits for discharges to surface waters under the Clean Water Act National Pollutant Discharge and Elimination System permitting program. We refer to that in Region 2 as NPDES. I think other regions may just call it NPDES, but I'm going to stick with the one-word thing. It's shorter. Those permits have technology-based limits as a minimum floor and must include any more stringent limitations necessary to meet applicable state water quality standards. For onshore, and it differs onshore and offshore, so for onshore gas extraction operations, the technology-based limitations require zero discharge to surface water in most cases. Onshore unconventional gas extraction operators can meet the zero discharge requirement by variously injecting wastewater into underground disposal wells, recycling wastewater for use in other fracturing operations, or sending their discharges to publicly or privately owned commercial centralized waste treatment facilities. EPA expects to propose a rule in the fall of 2014 to establish pretreatment requirements for onshore operators that could potentially send their wastewater to publicly owned treatment facilities. Under the Energy Policy Act of 2005, stormwater runoff from oil and gas exploration, production, and processing or treatment operations are in general exempt from NPDES permitting requirements. This slide illustrates the various uses of water in hydraulic fracturing processes, bringing the water to the site, mixing in chemicals and sand, pumping the water mixture to fracture the deposit, recovered water, and wastewater treatment or disposal. Hydraulic fracturing facilities that meet threshold requirements, for instance, the amount of oil storage, reasonable expectation of discharge to navigable waters or shorelines, are also required to prepare and implement a Spill Prevention Control and Countermeasure Plan, SPCC, for the prevention, preparation for, and response to oil discharges to navigable waters or adjoining shorelines. Under the Safe Drinking Water Act, it mandates that EPA protect underground sources of drinking water from endangerment related to underground injection activities. The UIC control program identified 6 major ways that fluids can escape through an injection well or zone and enter underground sources of drinking water. EPA developed minimum federal requirements for the exploration, use, and closure of wells based on those pathways. Although not initially subject to the UIC program, the courts have since held that hydraulic fracturing operations are subject to the Safe Drinking Water Act and that wells used for the injection of hydraulic fracturing fluids fit within the definition of Class II wells under the UIC program. I'm going to say so, I think it is so. In the 2005 Energy Policy Act, Congress revised the definition of underground injection so that operators need a UIC permit for a Class II well before injection begins. Here are the 6 classes of wells covered by the UIC permitting program. Remember, production wells are not regulated by the UIC program, although the states regulate oil and gas wells under authorities separate from the Safe Drinking Water Act. EPA issued guidance in February of this year setting forth its interpretation that the Class II injection well requirement applied to diesel fuels hydraulic fracturing and setting forth technical recommendations for implementing these requirements. Here's a rough estimate of the inventory of the various classes of wells nationwide. And it's important to remember that UIC injection wells that utilize diesel in the fracturing process are only part of the story. An extremely large volume of produced water and hydraulic fracturing return flows are disposed of through the use of injection wells that are also regulated as Class II wells. This has nothing to do with the presence of diesel fuels at all. Produced fluids are brought to the surface to allow the gas to flow to the surface. These fluids can be disposed of in an injection well or returned to the production formation to maintain reservoir pressure. The permit for injection disposal will include monitoring within the vicinity of the well to identify fluid flowing into drinking water aquifers through suspect penetrations. EPA also has emergency authority under the Safe Drinking Water Act to take action where contaminants in the drinking water supply present an imminent and substantial endangerment to the health of persons. I was not anticipating that we would have time, so I was going to just show you that these other slides exist. Air emissions, I cover that in detail, and again, the materials are in your printed materials. Hazardous and solid waste, Toxic Substance Control Act, and CERCLA. EPA is also still conducting research on the potential impacts, and the final draft report for peer review and comment is anticipated sometime in 2014. For your consideration, there are questions regarding hydraulic fracturing. One, these are all headlines from the New York Times from the past 6 months. The issue of induced seismicity, since injecting fluids underground at high pressures has long been known to cause earthquakes. Just ask the people of Oklahoma. 2, the use of millions of gallons of water in time of extreme drought. Ask the people of California. 3, just to bring it down to a regional level, New York State has proposed regulations for hydraulic fracturing, but the best that I can find out, they are still under review. They've been under review a very long time. They also can't be finalized until New York State Department of Health completes its health study, and the status of that is also unclear at this point. And also, interestingly, the Delaware River Basin Commission had proposed regulations on hydraulic fracturing, and that was several years ago, but they have not yet moved to finalize them. And finally, I'm going to call it the elephant in the room. I didn't have time to put this as a slide, but this is a photo that my daughter took at a Wegmans in Williamsport, Pennsylvania, 2 years ago. And it was over a water fountain. It says, "Safe to drink." It says, "This water is most likely safe. If you have any concerns about contamination," let's see, oh, sorry, I can't read it backwards. "Due to hydraulic fracturing, expose water to flame." If you've seen Gasland, that works. But it was, I asked Robin about this. It says that it's from the DEP. And so No. I wish it was in my slides, but anyway, here it is. And that's the end of that presentation. Thanks very much.
I guess we have time for a couple questions.
I'm not a RCRA expert, and I included some materials from that program in my materials that have been made available to you, so I'm not comfortable responding to that.
Does anybody else have a question? Yes.
I have a small question about the definition of gas. Everybody gives this gas the dignity of being a produced product, like a factory, like somebody made it. It was mined. Maybe we should call this process mining, hydraulic mining, because I think that's what it's doing. It's not producing anything, it's just taking it out of the ground.
Okay.
Yes.
In terms of hydraulic fracturing, what attention has been given to the radon issue in terms of the Marcellus shale, which is a very, very organic shale, meaning that it's high carbon? What information do you have in regard to radon being carried through the pipelines from this very organic shale?
I actually heard your question before. I've tried to find out an answer to that in the time between when you asked that earlier and now, and I've not been able to find out anything. Sorry.
Yes.
I just had a question as to the timing on when EPA was going to be releasing its report on the water quality impacts of hydrofracking that you've been working on for several years.
The draft study is, or the peer-reviewed study is supposed to be released later this year, but there's no absolute date on that.
There's been a lot of talk about resiliency and new government programs, whatever, but also I've been hearing a lot of expedited environmental reviews. What is New Jersey doing to make sure that new development does not impinge on resiliency plans?
So that's a great question. I think what you were asking was expedited reviews, and
Yes.
how do we ensure that that doesn't have a negative impact on the environmental side? So first of all, thank you for recognizing that we are doing some things in an expedited manner post-Sandy, because a lot of people do not tend to see that happening. So let me thank you for that. We do that balance all the time, and in fact, one of those transformation notes that I was talking about earlier in terms of trying to expedite permitting, a lot of it is about bringing the right tools. So getting more electronic opportunities to do permitting expedites without having any negative impact. Having more cross-program discussion expedites, because you're not having to go to the water program, get that permit. Now go to the air program, get that permit. Now go to land use and get that permit. Instead, we're doing permit coordination in DEP, where we bring all the programs together at one time and run parallel paths. So that expedites permitting as well. So, and the third part of it is more general permits or permit by rule, where if you follow what the law is telling you to do, you can get a general permit as opposed to an individual permit.
My question was more of a criticism than a compliment. I'm concerned.
Good job.
I'm really concerned that there's all these people here that we spent the whole day talking about this, and yet everyone, half the lawyers out there, most of the lawyers are figuring out ways to overcome, the environmental review that's there. That it's a slow process, and I'm saying we should slow down, not speed up some. The remedial stuff is fine, but we're still pushing through, reviews that we're building upon the waterfront as much as before. And I think there's something there that we're telling the public, the three levels of government are telling the public that we're doing all this stuff, and yet the exceptions are bigger than the rule. I guess what I'm saying is that could we slow down in the right cases?
So, and I would just like to give you a great example. We implemented the waiver rule in New Jersey 2 years ago under a lot of fire because people thought the waiver rule was going to be a way for folks to get over on us with our rules and be able to avoid our rules. Since the time we implemented the rule is so strict, we have not approved a single waiver yet in the state of New Jersey. So I think that is an example of trying to provide flexibility. What I like to say when folks come in for their permit is up front, number one, it's your responsibility, Mr. or Mrs. Permit Seeker, to have 100% transparency at the top of this process. If you give me 100% transparency on all the issues, we're going to identify the red flags. We're going to let you know immediately if your project's a responsible one. If it's responsible, we're going to get you on a path to getting you your permit. If it's not a responsible project, we're going to tell you up front before you spend $100 million trying to get through our process that you need to do this a different way, go back, figure it out, and come and see us. So what we've been trying to do is have a relationship with our regulated industry in a way that they understand what we expect when they come to the table for that pre-permit coordination meeting so that we can only move responsible projects in a responsible way.
Yes.
Hi, yes, this is a question for Phyllis. So we heard earlier about that the dredging of the Upper Hudson is almost complete for PCBs. We talked quite a bit today about this sort of surprise that the DEC had with the oil trains and the virtual oil pipeline. And so my question is, how focused is the EPA on the potential impacts to water quality, and particularly the Hudson River, of this new transport of these massive amounts of oil, and particularly how closely are you watching these proposals to modify certain facilities to enable them to handle heavier crudes like tar sands crude? And are you focused on the potential impacts of that on Hudson River if there were to be a spill?
We became aware of the Hudson River and the transportation issues at approximately the same time as everyone else, and probably all of us read about it in the New York Times at the same time. I know I am not directly involved with those activities, but I know that the region has been working over time to identify potential risks and address them within the scope of our jurisdiction, which is, as you probably know, somewhat limited.
Yes.
It's a question for Ms. Feinmark. I believe that there are places in the country where fracking waste is spread on roads as a way to keep down dust and a way to deal with snow and ice. So I take it that that's not a use that's regulated by federal law. Could that be changed by regulatory action, and if so, is that something that EPA is contemplating?
Region 2 finds itself in the unique position of having no hydraulic fracturing activity within our region. As of this point in time, there's none identified in New Jersey, and because the New York State regulatory authority has chosen not to promulgate their regulations, we do not have any purposed uses of hydrofracking waste in the area. I can only speculate as to whether that might be regulated. One thing that comes to my mind, if you're disposing or you're placing waste on a roadway in a wet period, then maybe you might have some stormwater issues, which perhaps EPA could regulate. But I really don't know of anything. If you would like to speak with me afterwards, I can look into other areas for you, other areas of the United States.
Just as a follow-up to that, there is the use of hydrofracking waste fluids on roads in New York currently. And that waste comes from vertical wells in New York and potentially from high-volume wells in Pennsylvania. So I just wanted to clarify that there is that practice going on right now. It's currently being approved by DEC under their beneficial use determinations. But as far as we know, they are not testing whatever the fluids are for norm for naturally occurring radioactive material. We're quite concerned about that, and we would urge EPA to take a hard look at that practice.
I think that's all. Michael's going to say a couple words to just wrap it up.
Thank you, Lori. As I said at the outset, the written materials are all available on our password-protected website, and the URL and the password are in the program brochures that you all have. We're going to post a video of today's proceedings on the website of the Center for Climate Change Law so that you can relive all the water-related puns. You can also go to that site if you would like to sign up for the Center for Climate Change Law's blog or our Facebook page or our Twitter account. That's www.columbiaclimatelaw.com. And finally, I'd like to ask all of you to do 4 things. First, if you are signed up for CLE, please remember to sign out in the sheets on your way out. Second, please fill out an evaluation form and leave it on the table outside. Third, please return your plastic name tags in the box outside so it can be reused. And finally, please join me in thanking all of our terrific speakers today.